see if this works right here. All right. Sound is gone. Of sound. Can you guys hear me now? Can you guys hear me now? Is there any sound on here at all? No volume? Mic check, 1, 2. Mic check, 1, 2. Can you guys hear me now? All right, cool. Thank you. We got a yes. All right. I didn't want to come on the stream, but whatever. So here we go. We're going to cover these terms dealing with our people. And again, this comes in light of the in wake of, unfortunately, of Miss Breonna Taylor and so many others who have lost their lives due to police murder. We're going to call it murder because that's what it is murder. But I felt compelled that we have to start by understanding law and understanding the language of law and how it applies. And it won't just be me. I'm going to bring on another good brother on here who's also very versed, he's becoming versed in law. So let's see if we can get him on here real quick. So again, write down these terms real quick for me, family, so you guys can have an understanding of what's going on. And I'm going to pull up some more information for you real quick. We're going to get started. We're going to jump right into this thing. All right, let me hit the good brother up real quick. And while we're waiting for him to jump on here real quick, I'm going to go ahead and pull up our first thing we're going to tap into, which is dealing with wardship. Wardship. Oh, no, let's do this then. Let's go to the 13th Amendment. Let's go here. Let's go here. Let's go to the infamous 13th Amendment. This is the amendment that everybody loves to talk about, loves to mention. Make it bigger. 13th Amendment. Oh, there we go. 13th Amendment. This was kind of where it all started at. Us. I'm saying us. When I say us, I'm going to use a lot of colloquial terms. The term colloquial means just for a common understanding. So I'm going to say black people. I'm going to say Negroes, but we all understand that there are no such people as black people, no such people as Negroes either. So I'm going to use those terms interchangeably to drive home a point. So let's start with the Constitution of the United States, 1789, revised in 1992. It states, Section 1, it's only 2 sections to the 13th Amendment. The 14th Amendment, we're going to talk about it as well. But the 13th Amendment says, neither slavery nor involuntary servitude, except as punishment for a crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. That means Puerto Rico, that means Hawaii, what else is Alaska, any other place that's subject to the jurisdiction of the United States Corporation. And the term jurisdiction should also be written down because we're going to talk about a lot of jurisdictional matters. In the case of Breonna Taylor, of course, jurisdiction was one of the things that came up. Not saying it came up in the media, but anytime dealing with a court of law, jurisdictional matters, it has to be presented, whether it's jurisdiction over the subject or jurisdiction over the individual. Okay, so let's move on. All right. So let's talk about the 13th Amendment real quick. The 13th Amendment was enacted due to supposedly 1865. We see that was not true. Yeah, it was drafted in 1789. It was drafted and then revisited or revised in 1992. So we think of the 13th Amendment as dealing with the 1865 emancipation of slavery, dealing with Abraham Lincoln. As you see here, the Constitution had already outlined in 1789, Section 1, Article 13. And we know the Article 13 and Article 14 were amendments, meaning that they had to go back and add the shit to it. The Constitution was written, or originally written in 1776 or 1774, apologize, with giving the United States their full authority. And the Constitution is only it's a set of bylaws, set of rules. Any organization any organization, whether it's the Masonic order or whether it's any organized, incorporated entity, they must have a bylaw and constitution. I mean, they must have a set of rules they go by. And this set of rules, unfortunately, they excluded so-called black people. They excluded so-called black people and had to go back later and add it because black people became what was known as a corporate artificial person. We're going to talk about that in a second. All right. So the 13th Amendment clearly just stated that slavery or involuntary servitude will not be tolerated. It's illegal unless you are incarcerated, right? And I'm going to read something else that was pretty interesting, just dealing with the 13th Amendment. Let me go right here. Bam. This is the term. This is the term that we must all know and understand when we're dealing with law. And as you guys can see, I wanted to do a PowerPoint, but I figured I'd just give you the citation and the sources so you can do your own research on your own. You already know me. Don't believe a word I say, but do your own research. I'm giving you guys the keys to do it. The term civil martus. Why is the term civil martus even important? What was it even relevant? Well, let's click here. The term martus means dead. Dead. It says Latin dead. So in the sheriff return, martus is state he is dead. Martus semperul, giving you different examples. But the term martus is dead. Another term that martus come from is the term mortgage. The term mortgage also implies a dead pledge. That's what mortgage means. So civil martus. And we're still dealing with the 13th Amendment, by the way. Again, this is more of a classroom setting, family. I'm sorry, I won't be shouting or doing anything crazy in this session. We'll definitely be learning, though. Civil term martus. Civilly dead. One who is considered as if they were naturally dead. Go as far as his rights are concerned. So as far as your rights are concerned, civil martus would be the term applied to any 13th or 14th Amendment so-called person. Oh, wait, my brother. Oh, here we go. So civil martus, dealing with anybody when it comes to law. And that's why the Moors oftentimes say that according to science, black means death. That's exactly what that shit means. You're dead in the eyes of the law. 1 second, family. I'm trying to add the good brother here. He's actually a lawyer in training. I'm going to add him to live feed here. Hotmail.com, Justin.Taylor 2. Boom. Sent. All right. So get a good brother to come on here. But civil martus is the terminology that definitely applied when dealing with Miss Breonna Taylor and some other people who were unfortunately murdered by the cops. Let's see what else here. Let's deal with let's go into the Civil Rights Act real quick. Hope you guys are writing this stuff down. Again, we say that more bullshit about to get debunked. Brother, we're not even dealing with more science right now. Unfortunately, this is just straight up information. That's why I'm providing you guys with the links to do your own research. Let's go into a corporate person. Let's do that real quick. And this is what happens when you agree to be this 13th, 14th Amendment black colored person, Negro. There we go.
Hey.
Peace, good brother. How you feeling?
I'm good, brother. How are you?
What's going on with you? Good.
Yeah.
Fresh off the plantation, I see.
Hey, yeah. Well, you ain't gonna do me like that.
Shit, I got to go back to the plantation here in another week to go get that money.
Yeah, my man, I see you moving.
Oh, absolutely, always, always. So we didn't get too far into anything, man. I was trying to stall a little bit to get you on here.
Okay.
And the only thing I kind of went over was just 13th and 14th. Well, 13th Amendment. I didn't get to the 14th Amendment yet. And as you can see on your screen right here, I just brought up. I covered civil martus also, civilly dead,
Okay.
and I was telling the family, you know, in the wake of Breonna Taylor and so many others, we have to examine their status for the record. Anytime any kind of cases are brought before the courts, status is put on the record for the record. Status
Absolutely.
of the person, status of, you know, jurisdiction of the person, jurisdiction of the matter, and I was just bringing up what a corporation or corporate person was, and we can actually go back if you want and cover some stuff that you want to get into. But I just want to just the point I'm driving to the family today is showing that if you're agreeing to be a 13th or 14th Amendment person, first of all, that makes you a corporate person, or what I like to call a corporate ward or corporate ward status. We're going to deal with wards in a minute. It says in 1886, but it wasn't until 1886 that Santa Clara County versus Southern Pacific Railroad that the court appeared to grant a corporation the same right as an individual under the 14th Amendment. That became clear to me that under the 14th Amendment, they were creating these corporate fictitious people who we have to call a straw man. And if you are agreeing to be a corporate fictitious person under the 14th Amendment, being labeled Black, Negro, colored, African American, then you are deprived of certain rights. And the word that I had put up there was civil mortuus, meaning civilly dead. You know, you're exalted of all your rights. So you want to kind of jump in and kind of catch us up on.
So you know what jumped out at me when you read that that blurb below 1886. It says that the court appeared, right? So you still there?
Yeah, we're good.
Oh. Yeah, so it said that the court appeared. So what we have to understand is that, first of all, you know, everything that the court appears to do is exactly that. It's an appearance. It's not, the law is colorable. It's fake. It's fictitious. And I was just doing some reading today, and it seems like, you know, we keep coming back to the same place. You know, we're back in this position again. And we have to understand as a people that everybody with a birth certificate, we are legal transferable property of the state.
Wow.
So
okay, now you got to get into that part now.
We're asking for justice that we don't even deserve because we're not in our proper person. So all of this crying and this pleading and this begging for justice, they don't owe us justice. They don't owe us justice. When we accept that misnomer, that black and that you know, that African American, and there is no justice for that.
Wow. So what the remedy then? And I know we get into it later, but what do you think the remedy is to remedy our people from that thinking?
Well, the remedy would be to we have to establish ourselves in our proper person. We have to release this. We have to let go of this this fantasy, this facade that has been, you know, ingrained in our minds from grade school, that, you know, that black and African American is a thing to be, and we've accepted this pride for being fake. Black pride shouldn't be a thing. We're proud of something that doesn't even legally exist, and so then when we make these cries for justice, when we make these cries for equality, there's nothing to. I mean, there's nobody to give equality to. One of the senators did a press conference, and they were talking about reparations. Mitch McConnell. They were talking about reparations, and nobody. I don't think very many people caught it. But Mitch McConnell, he said, on live TV, he said, who would we even give reparations to?
And that's the thing.
There's no nation. There's no. You know why Jews? You know why Japanese? Why they got reparations? Because there was a nation backing them. There's no nation backing Black. There's no nation backing African American. So there'll be no reparations.
Zero.
There'll be no justice. Go ahead, brother.
No, I mean, you make a good point. And I wanted to draw people's attention back to the Civil Rights Act of 1968. There was one in 64 also that we can point out. The one in 68, though, this was the one that caught my attention. And again, we're dealing with civil more too, civil rights, civil. Nobody's talking about human rights yet. So right here, the nickname for the Civil Rights Act of 1968 was also called the Indian Civil Rights Act, the Indian Bill of Rights.
Okay.
And I wanted to call it that. See, the civil rights were set up for a nation of individuals. But see, when you lay claim to Black, Negro, and color, you're outside of that family, so it doesn't apply to you. And it says right here, the Indian Civil Rights Act applied to the Aboriginal Americans of the United States who suffered discrimination during the turbulent 1960s.
There you go.
You didn't see
America.
Right. You didn't see any so-called long-haired, high-cheekbone Indians get bit by dogs and sprayed with water hoses and mistreated. They're talking about your ass, but we're too busy. We're too busy saying that we're Black. Now, around the same time in 1960, James Brown put out a infamous song, "I'm Black and I'm Proud." That song was used politically to leverage the people behind the idea of them being Black. Around the same time, it was given the Indian Civil Rights Act to let us know, hey, you Aboriginal people who were already here, descendable of the descendants who were already here, you guys have civil rights that we're gonna afford you, right? Now, what we think the Civil Rights Act did for us is it stopped segregation, it stopped Jim Crow racism, and that's not what it was put out for. There was a couple of different Civil Rights Acts also. You see right here, it's the Anti-Riot Act. They had the Open Housing Act. The Open Housing Act opened the floodways for the housing project. So we have to understand this thing is whole, or so-called Black people, and why are they getting the long arm of the law thrown in the book thrown at them every single time they go to court, anytime something happens to them, and legally who are these so-called Black people legally? Like who are they on paper when it comes to the court?
Right. So and that's up for each individual to determine. It's you know what I'm saying. It's your job to determine who you are legally and how you're going to represent yourself. Now, if you go in the door, saying Black, African American, da 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 da, everything that we've been taught to say, then you have just legally forfeited all of any rights that you could have possibly gotten. Right? And they're not going to tell you that. And they're hoping you do that.
No.
So it's up for us to, educate ourselves and teach our children, what's correct regarding who we really are. And it's gonna. And our problem is we're lazy. We don't want to read. We don't want to do the work. We're satisfied with accepting, what someone else tells us versus doing the work, doing the research, and figuring out who we really are and what we are really entitled to, and then taking the steps necessary to get it.
Right.
So until we start reading these books, man, having these conversations like we're having now, and breaking this stuff down, and each one teaching one, we'll keep repeating the same cycle, and they'll keep capitalizing off of our emotionalism, our lack of intelligence, or I don't want to say lack of intelligence, but our lack
No,
of
no, 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 no,
knowledge.
no, no, no. Right. I'm apologize for a second, and I'm glad you said lack of intelligence, because that's what it comes down to, brother. It comes down to them saying that we're feeble-minded.
Okay,
If you look up
yeah.
the term feeble-minded, feeble-minded was a term that was used politically during the era of the early 1920s with eugenics project, and they declared that if you were unable to read or write, you were declared to be feeble-minded. We have to understand, in 1920, there was just I don't know, 30 years, 30 years after the supposed emancipation of slavery. So you have these farmhands coming off these plantations in the South with no education,
Right.
not due to the fact that they're stupid or dumb or not intelligent, due to the fact that plowing a field afforded you life versus reading a book. So illiterate would be the term to use, but they use that term feeble-minded or just not intelligent as a catalyst to also sterilize a lot of our black women during the 1920s. So you got to be careful. Now, what I want to get on real quick is I'm going to read the definition. I want to turn you loose on that Black Law's Dictionary, because I know there's some good nuggets in there that they definitely need to hear. So dealing with the term black family, I know that people want to say, the ancient black gods of Egypt and black this, black that, black, 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 black. Words, terms, vibratorial messages, waves, they carry energy. So if we keep perpetuating this black consciousness, this black brand, this black information, it's going to continue to happen to us. So dealing with terminology and terms, there's something in English called the lexicon. The lexicon is the law of the language. And if you unfortunately don't understand the lexicon, then you're declared to be dyslexic. So the word black, we're dealing with the etymology of the word, but the origin of the word. The etymology of black, it says the word black comes from the Old English bleak, black, dark, also ink, from the Proto-Dramatic black, burn, the Proto-Indo-European blang, burn, gleam, shine, flash, from base bleed to shine, related to Old Sax black, ink, High German black, etc. Where else said Dutch too? No description you see African. You didn't get a part in that. At the bottom it says, what is the original meaning of black? The word black can be traced back to its Proto-Indo-European origins through the word block, which means pale, colorless, albino. In Old English, black person meant fair, someone devoid of color, similar to the word blanc, which still means white or fair person. So when our people running around here saying that they're black, Black Lives Matter, again, that feeble-mindedness, they're feeble-minded.
Right.
So when a black person is shot, unfortunately, or murdered indiscriminately, then that's what they related back to. Like, well, they said they thought they were a Creon. What does Black Law's Dictionary say about this? And to tell people what is Black Law's Dictionary?
So the Black Law's Dictionary, I have the 11th edition, and the Black Law's Dictionary is basically it is the active. It's the Bible as it pertains to the law in the United States. Every legal term, legal tender, it has all of our Declaration of Independence, the United States Constitution. It is all in the Black Law's Dictionary. When you are being tried or in any situation where there's a court appearance or anything involving judiciality in the United States, the terms that they are using that oftentimes we don't know are coming directly out of the Black Laws Dictionary. This book can be purchased on Amazon. I got mine for like, I think I want to say like $80. You could get them on eBay, but it's definitely a great tool to have in your library, just so that you could, just so that you can learn. Because it's difficult to fight a battle when you can't speak the language. If you can't speak the language, you've lost before the battle has even begun. Especially a battle of debate, and basically that's what law is. It's debate. So let's jump right in. Let's see, where will we go first? First, you got to understand the difference between civil law and common law.
Okay.
Right. So common law refers to a high-level definition is the law of the land. Right. Common law is the law of the land, and I'll read it to you out of the Black Laws Dictionary. Common law of relating to, involving, or according to the common law. Common law is a French term, the body of law derived from judicial decisions rather than from statutes or constitutions. Case law, federal common law, or statutory common law. Historically, the common law is made quite differently from the Continental Code. The Code precedes judgments. The common law follows them. The Code articulates in chapters, sections, and paragraphs the rules in accordance with the judgments that are given. The common law, on the other hand, is inarticulate until it is expressed in a judgment. Where the Code governs, it is the judge's duty to ascertain the law from the words which the Code uses. All right. So where the Code judges, it is the judge's duty to ascertain the law from the words which the Code uses. So that goes back to what you were saying. You have to understand what the meaning of the words are, because the judge is going to render his decision based on the meaning of the word, not based on what you think it means. All right, so let's see. So let me jump over to civil law. And then we'll talk about the difference between
listen,
the two.
I want the family. I want the family to understand that you're reading directly out of the Black Laws Dictionary. These are not notes you have taken and inscribed for yourself. Everything we're showing you, there you go. Everything we're showing you, family, you do the same thing that we're doing. It requires a little bit of research, a little bit of time and effort on your part to understand what's going on when it comes to law. You can't get emotional about these things. There are scripts already written on how to handle certain situations, procedures. Certain protocols are in place already for this stuff. When the brother's breaking down the measure on the civil side, as he's reading this stuff, keep in mind anything that's pertaining to so-called Black people and Negroes is always a civil case. Go ahead, brother.
All right, so civil law, one of the two prominent legal systems in the Western world, originally administered in the Roman Empire and still influential in continental Europe, Latin America, Scotland, and Louisiana, among other parts of the world, right? Roman law denotes the body of Roman law from whatever source derived, but it is also used to denote part of the Roman law peculiar to the Romans, as to opposed to the common law of all peoples. As to opposed to the common law of all peoples, right? So civil law is opposed to common law. The difference between
suppose, we mean opposed. Yeah.
Say that again. I couldn't hear you.
when you say that civil law, you said civil law is opposed to common law.
Yes, the civil law is opposed to the common law, meaning civil law doesn't always follow the statutes of common law. It's situational, and I'm going to get into that in just a minute. It's situational, and basically what I mean by situational is oftentimes you hear when lawyers and judges, when they try cases, they often bring up the verdicts of older cases. They might say like, well, based on the results of Brown versus, Ferguson in 1966, that's when they're leveraging a judge's older decision to get a favorable decision in this case. So that takes common law off the table, because what judges have to do is, if they find an instance where a previous judge ruled a certain way on a case, they have to side with the previous judge. They can't contradict what the other judge did. That's why they use that leverage. Whether that judge was right, wrong, it don't even matter. They have to side with the findings of the older judge. So
gotcha.
Now let's talk about civil law and criminal law, because that's the topic, right? Civil law and criminal law. The difference between civil law and criminal law is it turns on the difference between the two objects which the law seeks to pursue. So the law has a end goal in mind, right? Every law is pursuing a specific end. There's an end in mind. So the difference between the two, civil and criminal, is what the law is pursuing. All right. So in most cases, civil law is pursuing settlement. Criminal law is pursuing prosecution. Right? Redress.
Hold on a second. So hold on. So Ben Crump, is Ben Crump a civil attorney or a criminal attorney?
Ben Crump is a civil. Ben Crump is a civil attorney. Ben Crump has done his job every time.
He got the settlement.
He got the settlement,
right?
His job is done. Go ahead.
Why is it that people seem to be upset at the police department and the governor and the DA and Black Lives Matter? Why aren't people turning their guns toward him for not pursuing criminal charges? I mean,
because
I just thought about that.
Because we don't understand. We don't understand. We don't understand the terms. We don't understand the process. Law is a process, and depending on what you are pursuing, that determines how you use the law, either in your favor or to your detriment.
Right.
So in this case, since this is the most recent, in the Breonna Taylor situation, the family accepted a settlement, and like most families do, right? They accepted a settlement. And I can't say that they were wrong for accepting a settlement. You're talking about people on hard times, and they're gonna offer you $12 million. What you gonna do in that situation?
They're gonna
probably 95% of the people on here are gonna take that settlement, right? But the terms of the settlement is this is a contract. This is a contract you're entering in with the state. The terms of the settlement are: you take the settlement. You cannot, under no circumstance, pursue any charges against the state after the settlement has been granted.
Right, that's right.
Right? You cannot, under any circumstances, seek for
any remedy.
No, it's once you take the money, that's it. But see, we don't know that. You know, the public don't know that. So the public is seeing this and they're saying, you know, great, she got the settlement. Now let's get a prosecution. No, it was over from the moment the settlement. And you see, they all knew this already. We don't know this.
Right.
From the moment the documents are signed and you say, I'll take the money, case is over.
That's it. Hush money.
Case is over.
It becomes hush money.
It's hush hush. That's exactly what it is. And you gotta ask yourself sometimes, you know, when you see all of these things going on, you see the whole city is in an outrage. You know, they got their marching, they have banners up, they have flags and all of this kind of stuff. And yeah, people are hurt because it keeps happening. I understand. But the people that should have been the most hurt weren't there. Where was the family? I didn't see the family marching. I ain't see, you know, I ain't see none of the family members out there marching. You know, you got Black Lives Matter out there organizing, and I mean, if that, you know, it just seems like the family members would have been right in the thick of all of the organizing and all of the protesting and the, you know, but everywhere you go, you know what I'm saying? George Floyd, once the settlement was, did you see any family members out, you know, burning down buildings and, you know, the people that should be the angriest? No. Once that settlement is done, they in Cancun. We over here burning down buildings, and they just got 12 mil yesterday. They in Cancun. So yeah, back to civil law. So the object of civil law is.
Hey, listen, you're right, exact.
Say it again. I think it's freezing up on me. You there?
No, go ahead.
Okay, so the object of civil law is the redress of wrongs by compelling compensation or restitution. Civil law seeks restitution. The wrongdoer, get this, right out of the dictionary. The wrongdoer is not punished. Do you hear me? The wrongdoer is not punished. He only suffers as much harm that is necessary to make good on the wrong he has done. So if you,
I'm gonna pull something up for you.
Okay, let me adjust this right quick so hopefully I get a better signal.
Okay, so right now we're about 117 viewers on here. You're on Crumb TV. Be sure to subscribe to Crumb TV. Click the bell, man. This is your boy, Minister of Information. I have brought on my man, Justin, aka Justice. He's giving you guys some legal remedies to go study so we can really understand what's taking place with so many people that's being murdered, man. Rest in power, Breonna Taylor and everybody else, man. George Floyd and everybody who's been, you know, wrongfully mistreated by this fiduciary system. And I'm also gonna, after the brother finished telling, he gonna read that again. I want to show you guys something else historically that read the same way, and then we're gonna talk about colorable law right after that. Read that one more time.
Oh, well, I was just looking at that. So back to civil law and family. The only reason I'm bringing this to light is because I want us to understand what's going on, and we can't understand if we don't know the language. Every time we see this play out, it's the same process, right? One of our brothers and sisters are unjustly, murdered or whatever happens. The first thing that happens is in comes the civil, right? And we're angry, we're upset. We want punishment, but the first thing that they offer you is a civil attorney. It's all by design.
Yep.
It's all by design because they already know if I can bait you with the civil,
You won't
right?
proceed criminal.
You can't proceed criminal. You can't pursue
Yep.
criminal because you took the bait. And like I said,
Dang.
I'm not saying anybody is wrong for taking any money. You know, I probably would have took the 12 mil too. I'm not saying that, but what I'm saying is we have to understand so that our expectations can be aligned with what is factual as it pertains to the law.
Yep.
Okay, so let's talk about civil law. Ben Crump, Lee Merritt, all of those guys that we see on TV, those are civil attorneys. They're not criminal prosecutors. They're civil attorneys. Their job is to seek redress, not punishment. Okay? Straight out of the dictionary, it says the object of civil law, i.e., civil attorney, is to redress the wrong committed with compelling compensation or restitution. The wrongdoer will not be punished. This is in the Black's Law Dictionary. This is what the judge is looking at when he's making his decision.
Wow.
Jail time, according to the law, you took the settlement, you signed the contract, ain't nobody going to jail. That's it.
Nowhere.
It's closed.
Now look, I don't know if you can see this very good on your screen, but it was called the Casual Killing Act. And the Casual Killing Act read, whereas the only law enforced for the punishment of refracting servants or resisting their master, mistress, or overseer cannot be inflicted upon Negroes, nor obscenity of any of them by other than violent means suppressed, be it enacted and declared by his grand or by his master or correcting him, and by extremely of the correction should chance to die, that his death shall not be accompanied felony by the master or any other person appointed by the master to punish him. Basically, be acquitted from molestation, since he cannot presume that presented malice was alone makes further felony. So what the Casual Killing Act read, I should have got a better version of it, but the Casual Killing Act said if you're correcting the behavior of a Negro, correcting their behavior, if you're getting out of line and you're correcting their behavior and you cause malice or injury or death, the person that's causing the injury of death, white people, mostly masters, will not be held accountable and will not be tried as a felon. It's just a loss of property, pretty much. So when you just read that dawned like it's not the Casual Killing Act. If something like that happens and the person that causes the injury cannot be pursued criminally,
right?
And this is the Casual Killing Act of 1669. It was written, man. That came to mind. Now what I want to jump to real quick is dealing with.
Hold up. So let me read, because let me read color of law and colorable definitions out of Black Law Dictionary, since we on that topic. All right.
Okay.
So colorable, and it says colorable. All law is colorable, appearing to be true or valid or right, intended to deceive, counterfeit. The court found the conveyance of exempt property to be a colorable transfer, and so set it aside. That's colorable. Color of law, the appearance or semblance without the substance of legal right. The term implies a misuse of power is made possible because the wrongdoer is clothed with the authority of the state. Now, the misuse of power is made possible because the wrongdoer has been given authority by the state. Okay? Every person that has a birth certificate is property of the state. I'm sorry.
Whoa.
Anybody want to hear it?
Wait a minute. Hold on.
Even in the state of Virginia, do you know? And brother, I just found this out recently that when my child was born, I don't even have custody of my own child.
No, you don't.
You have to go down to the state and request custody of your children. Once you sign your birth certificate, you have given custody of your seed to the state.
Now, hold on for a second.
Because of color of law, they can now exercise a false sense of authority over a human being because that human being has become their property.
Hold on.
Go ahead, brother.
Time out. I'm glad you got to that shit now. Now, I'm about to show you how we got to that. And before we get to that, we have to understand that these 48 colonies or nations, or what we call states, all states or nations, okay? They're sovereign to their own, to each state is sovereign, but their sovereign power lies under the federal power, which is Washington, the District of Columbia. So what am I talking about? Each territory, each state, each province, each parish, whatever you want to call these geographical demarcations, they're all set up as colonies. We have to understand, Georgia never stopped becoming a colony. Virginia is still a colony. New York is still a colony. Florida is definitely a colony. And Texas is a colony. So with that being said, who presides over these colonies? It was the same powers that got them here, and that's the Crown of England. When the brother just made the point of the children you give birth to in the hospitals, and when you sign these birth certificates, and let's be real, the mothers who do these are doped up. You know, they're got medicines and stuff going on. They just gave birth, so they're not in their proper mind, if you will. I wanted to show you guys something real quick if I can find it. Etymology screen. I think it's down here. Bam. There we go, right here. All right. So this idea of the state owning a child, something that's called wardship. And this explains wardship. It's a jurisdictional matter because the ward of the child or the infant falls under the condition. Now, I covered this in my Juneteenth thing too. And there's a term I'm gonna bring back up. Whatever the condition of the mother is, the child follows the condition of the mother. So wardship jurisdiction is an ancient jurisdiction derived from the crown's duty as a parent party. You see that? And it means parent of the nation. Each state is a nation. Each nation is a state. Parent of the fatherland. Africa is the motherland. America is the fatherland. To protect his or her subject, the particular those unable to look after themselves, that's the term minor. I'm gonna show you the term minor. If you look up minor in your Black Law Dictionary real quick, brother, minor. The root word minor gives you the elongated word minority. So if you're a black minority, you're in double trouble. All right. So it says other Commonwealth realms. They use realm. That's we won't get into that. But the queen as a parent party is the mother for all children in her realm. The United States still belongs to the Queen of England. A court may take responsibility for legal protection of individuals, usually either a child, incapacitated person, in which case the ward is known as the ward of the court or ward of the state. You see that? So this is what the term ward of the state means, or ward of the court means. And if you look at your birth certificate, it'll say ward. The term ward is on there. You belong to the particular state of Nevada, or the state of California, or the state of Georgia, or wherever you reside at. You become property, and the state becomes the guarantor of that certificate. Just wanted to point that out. And add value to what the brother was saying when dealing with wardship and how when your child is born, how the wardship is awarded to the individual. Now, there's a court case real quick right here. I'll cover real quick, and it's United States, the Supreme Court case, Cherokee Nation versus Georgia. This is when, and let's be clear, the Cherokee people were people of dark color. Dare I say black people. This Cherokee Nation versus state of Georgia. The native people were legally made to be wards of the state. One consequences of this was that they were not permitted to sue the U.S. government because of their status as a dependent nation. The Indian Appropriation Act was passed on March 3rd, 1871, with the amendment ending tribal recognition in the treaty system. All Indians were made wards of the state. Thus, the U.S. government no longer needed to tribal consent in dealing with their tribes. You see that? The Indian Appropriation Act. And there's other Indian acts too we can get into that when our people realize or try to figure out, well, if I'm not from Africa, then who am I? Where am I from? They have screwed the paperwork up so bad for us, man, that we don't know what the hell we are anymore. But we're going to find that remedy right now. You know what I mean? So what does it say about a minor in Black Law's Dictionary?
They changed it. Okay. But I know exactly what you're talking about. But if I had I got the 4th edition electronically, and that was the one written back in like the 1800s. But in this 11th edition, they changed it to someone who has not reached full legal age, a child or juvenile. But in that 4th edition, it talks about your mental capacity. It also talks about mental capacity. It talks about not being. It talks about color. But yeah, they changed it in the newer version of the dictionary.
They updated it. So let's read right here. Yeah. According to law, a minor is a person under a certain age, usually the age of majority, which legally Democrats Democrats, childhood and adulthood. The age of the majority depends upon the jurisdiction and application. So the point I want to make is, if you are a minor, a person not of age, that automatically makes you a
ward of the state.
Right. Basically.
Yeah, ward of the state.
That's exactly what you become. So what I want to demonstrate is the root word to minor is minority. That's the root word, minority.
Exactly. So it automatically implies that all blacks are minors.
Yes.
Yeah, and that's what it was saying in the 4th edition. In the 4th edition of the Black's Law Dictionary, it expressly spelled that out. Yep. So if you are a dark-skinned minority, then that's a problem. That's a double problem.
Yep. Double penalty. So what I'm going to do, because I did a PowerPoint a long time ago dealing with this stuff, and I want to show people some of the recourse of some of my work real quick. This thing's different. All right, here we go. Okay, cool.
And while you pull that up, I want to say something about why the reason all of this is so important is if you read the Constitution of the United States, and if you read the Declaration of Independence, both that are in this book, I don't know exactly which article and amendment it is, but they make reference to all of those treaties that we were talking about earlier. They are bound by, the United States is bound by treaty to treat Indians, Aboriginals, however you want to identify it, whether it's Moorish, whether it's Aboriginal, whether it's Native American. The United States is bound by treaty to respect and treat those people a certain way. But because we don't claim those titles, we claim Black and African American, that they don't have to honor the words of those treaties. Those treaties are still in effect to this day, written all the way back, and they're what is it? What's the word I'm looking for? Renewed. What is it? Every 50 years, I want to say it is. They're renewed every 50. So it's important because by not claiming, Aboriginal, Indigenous, or Native American, or by not claiming those titles, we forfeit the protection of the U.S. Constitution. There you go.
Listen, that happens automatically. And when we dealing with the terms and the language, which you just pointed out, that is very, very important in a court setting. We have to be right and exact. A lot of people don't really know what term to use, and we may use the word Aboriginal, and we have to understand that the term Aboriginal means away from the original. When we say Aboriginal, the word Aboriginal comes from the word Aborigine. Right. Aborigine is a different word from Aboriginal. The word ab means away from the original. So when we're dealing with the term Aboriginal, that won't fly either. Yes. Okay, give me 1 second. Okay. We're dealing with those terms. I thought I had it here. I can kind of show you guys real quick the difference of what a Indian is, what the Aboriginal is, and what the indigenous people are. Okay. And that's something very important that we have to also understand. But let's move on to because we already at the 1 hour mark. Let's move, see if we can get into this PowerPoint real quick. I want to point a couple of things out, and maybe you can back me up with some of your literature you have in front of you. This particular point right here comes from the Holy Quran, the Moorish Science Temple of America. Yes, Moorish Science is definitely going to come up because Moorish Science was the only people that I'm aware of that was talking about nationality, birthrights, besides the Hebrew Israelites, dealing with birthrights, etc. Noble Drew Ali was the only person that I heard of that was teaching Black people in the 1920s that we're not Black people, we're not Negroes, we're not colored folks. And chapter 9 points out something interesting. It says, according to all true and divine records. If you're not sure what a true and divine record is, a true and divine record is any kind of canon law. We deal with all law. We deal with canon law, natural law, and of course, universal law. So the Holy Quran would be almost considered to be a canon law. But it says, according to all true and divine records of the human race, there are no Negro, Black, or colored race attached to the human family. And I found it to be quite unique because, as I did my research, there were no Negroes. There's no such thing as a Negro. And we're dealing with race. Race only refers to a person's physical characteristics, such as skin and hair color. So race is a pseudoscience. Ethnicity, however, refers to the cultural factors include nationality, regional cultures, ancestry, and language. So even from a ethnic point of view, we're still outside of that gauge of being a part of the human family. And as the brother pointed out, when we're dealing with Black people, we're dealing with Negroes, dealing with African Americans, those three identification markers, the nomenclatures, are all misnomers. And if you're proclaiming to be those things, you are outside of the law. You're considered to be an outlaw. And unfortunately, when the constable's on patrol or the cops deal with you, they can deal with you accordingly without fear of any type of recourse. Those who are smart enough, and they're protected by a union, by the way. So the union reps already know that there are no such people as Black people. And the brother was reading directly out of the law book that they deal with. And I advise all you to get you a copy of the Black Law's Dictionary. Like, don't get the Jordans next month. Like, fuck those Jordans. Like, get you a pair of books instead of a pair of shoes. And definitely read their Black Law's Dictionary. And it can help unveil a lot of the recourse that you need to be dealing with. So again, brother, I hate, man, but we're at 1 hour and 6, and on Crumb TV, we don't have to go past an hour in here. I definitely would like to get you back on here at the early part of the hour with Sister Shantae, and we really can get down to the nooks and crannies of a lot of this information, because a lot of it is top heavy. It's dealing with what like they call legalese, and sometimes it doesn't come across as clear to a lot of our people. One thing I think you did touch on earlier was when we deal with in a court of law and not being your proper person or your proper persona. And we have to understand, anytime you enter a courtroom and you're not in your proper person, they will quickly assign a procurator to deal with you.
Prosecutor.
Right, to quickly deal with you. But this is only part one. Soon the good brother Justin give me his schedule for this weekend. We'll definitely hop back on here again at an earlier time if we got time this weekend.
Absolutely.
And we can. And I'm gonna talk to my brother Crum, see if we can go past an hour and maybe go into the hour 45-minute mark and really dive into this stuff. And the PowerPoints I'm showing you guys to the right over here, I'm gonna go into how they actually came up with a lot of the pseudoscience, and they had to scientifically break you down as a person in order for it to be okay to kill you, lynch you, burn you, shoot you.
Let me say this right quick.
Please.
The word race ain't even in this book.
Wow.
There is no definition.
It was a made-up term.
There is no definition for race in law. Now they talk about race relations, but race, as it pertains to our understanding or the way we've been taught what race is not in the legal book. So
at all.
At all.
So once again, family, thank you guys for tuning in for another educational episode of Crum TV. I am your good brother, Minister of Information. Please go follow me on Instagram at Minister Informing. Brother Justin, what's your social media?
I'm just Justin Taylor on Facebook. On Instagram, I am just incredible, just_incredible. It's been a pleasure being here with you tonight, good brother, and hopefully we can do it again. Knowledge is power.
Listen, y'all. Crum, I don't know if y'all can see that. You probably can see that, but Crum just texted me. He said he would like to go live next. We've got to bring the good brother Crum on the platform with the brother Justin. And we're going to bring Shantae up here as well. And we're going to get into Nix and Cranny, man. We're going to talk more law. We're going to talk more civics. We're going to talk a lot more law and a lot more civics, people. So please, anytime the Minister of Information hops on here, get your pen and your paper. Let's start our own thing, man. Let's build our own shit. You know what I mean? In the meantime, go order that Black Laws Dictionary. What edition do you have? 8th edition? It's the latest one, right?
I have the 11th edition.
Oh, 11th. Wow. Okay.
Yep.
I have the 8th edition, and the 8th edition reads a lot different from the 11th edition. Of course, the 4th edition tells you that the Americans were the copper-colored people originally found here in America. So that's the 4th edition Black Laws Dictionary.
You can get the 4th edition online PDF. You can get that. You can download it for free. The 4th edition.
There you go, family. Go download the PDF version of the Black Laws Dictionary. 4th edition is free right here on Crum TV. Be sure to subscribe. If you're not already following the link or following us, what we're doing on the broadcast, share it. Share this episode right now. Part 2, Part 3, Part 4 is coming. We're going to get to the bottom of what's going on in America, man. What's really going on with the unnecessarily murder of our people. But first, we have to educate ourselves on who we are according to science. I'll leave you with this. This is, again, the more science people say. According to science, Black means death. What science are they talking about? We're talking about political science and social science. So part 2, we're going to jump into the political and social side of things, dealing with the term Black, Negro, and color. And you guys have to understand there are no such people as Black, Negro, and color. These are all terms given to you by slaveholders in 1776. And it lasted about 1865. That was the time of the end of slavery, when President Abraham Lincoln converted the United States of America to the U.S. Corporation, and we'll deal with that later too. So until next time, man, from TV, man. Oh, that was Mr. Jackson. Peace and love. Shout out to brother Justin. Thanks for coming on the platform, man. Only on Crum TV. Peace.